Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Cleveland, decided April 15, 2025. Singhas, J. We have previously held that an individual's flight from a level 1 or 2 police encounter, without more, does not provide the reasonable suspicion necessary to pursue them. See People v. Holmes, People v. May, see generally People v. DeBoer. We now hold that when a suspect flees during a lawful level 3 stop founded on reasonable suspicion of criminal activity, police may pursue the suspect. Defendant was arrested after abandoning a plastic bag containing crack cocaine while being pursued by police. Before trial, defendant moved to suppress this evidence on the ground that the pursuit was unlawful. At the suppression hearing, Officer Kyle Eisenhower of the Rochester Police Department testified that, on the night of the arrest, he was in uniform in an unmarked patrol vehicle with his partner, Officer Jeremy Nellis. The two were driving behind a sedan when a woman on the sidewalk threw a glass bottle at the sedan, which then came to a stop in the middle of the street. Defendant exited the driver's door of the sedan and in a very aggressive manner began yelling at the woman and approached her with clenched fists. According to Eisenhower, it appeared that defendant was about to attack the woman. Eisenhower and Nellis exited their patrol car and told defendant to stop, and defendant stopped and looked in their direction. The uniformed officers were about 25 feet away from defendant without their guns drawn. Defendant began to back away, and then quickly turned and began digging in the front of his waistband and running away from the officers, leaving his car in the middle of the street with the driver's door open. The officers followed in pursuit. About 50 feet into the chase, defendant discarded what looked like a plastic bag with some type of white substance onto the ground in a vacant lot and then continued running. Eisenhower believed that the plastic bag may have contained drugs. Eisenhower and Nellis continued the chase into another vacant lot when defendant stopped, and the officers ordered defendant to the ground and arrested him. Nellis returned to the location where they had seen defendant toss the bag and located a clear plastic bag containing what appeared to be crack cocaine. Defendant's car was gone. On cross-examination, Eisenhower admitted that when defendant stopped and looked at us, any type of physical attack against the woman had been prevented. But Eisenhower asserted that, when defendant stopped, he and Nellis had to deal with the fact that defendant backed away and began making those furtive movements in front of his waistband and running away from us. Eisenhower confirmed that when defendant discarded the plastic bag, the officers had been chasing him for approximately 50 feet, and defendant was no longer going toward the woman. Supreme Court largely credited Eisenhower's account of the incident, determined that the pursuit was lawful, and denied defendant's suppression motion. Defendant proceeded to a jury trial, and the jury found defendant guilty of criminal possession of a controlled substance in the 4th degree and aggravated unlicensed operation of a motor vehicle in the 2nd degree. The appellate division affirmed. Because the stop was supported by reasonable suspicion, the court concluded, the subsequent pursuit was also supported by reasonable suspicion, especially considering that, immediately following the stop, defendant turned his back to the officers, grabbed at his waistband, and then fled on foot, leaving his vehicle in the middle of the street with its driver's door open. One justice dissented. In the dissenting justice's view, once officers directed defendant to stop and he stopped approaching the woman, the reasonable suspicion that defendant was about to commit a crime ceased to exist at that point. The dissenting justice further reasoned that defendant's digging at his waistband, flight, and leaving his car in the street do not provide additional specific circumstances indicating that defendant was engaged in criminal activity. The dissenting justice granted defendant leave to appeal. A court's focus during any analysis of a governmental invasion of a citizen's person must be on the reasonableness of the police conduct. People v. Batista. Under the four-tiered framework set out in DeBoer, pursuit of a fleeing suspect constitutes a level 3 detention, for which the police must have a reasonable suspicion that defendant has committed or is about to commit a crime. People v. Martinez, citing People v. Long. Like a level 3 stop, pursuit results in infringement on freedom of movement, but a lesser interference with freedom than does a level 4 arrest. Thus, A defendant's flight in response to an approach by the police, combined with other specific circumstances indicating that the suspect may be engaged in criminal activity, may give rise to a lawful pursuit, People v. Sierra. Flight alone, however, or even in conjunction with equivocal circumstances that might justify a police request for information, is insufficient to justify pursuit because an individual has a right to be let alone and refuse to respond to police inquiry. Holmes, C. May, see also People v. Moore, People v. Howard. A stop based on reasonable suspicion will be upheld so long as the intruding officer can point to specific and articulable facts which, along with any logical deductions, reasonably prompted the intrusion. People v. Brennan, quoting People v. Cantor. Whether police conduct in any particular case conforms to DeBoer is a mixed question of law and fact. People v. Barksdale, quoting People v. McIntosh. Therefore, the court's review is limited to whether there is evidence in the record supporting the lower court's determinations. Initially, defendant suddenly stopped in the middle of the road, exited his vehicle, leaving a car apparently unattended with the door open, and approached the woman with clenched fists. Given the woman on the sidewalk's violent actions precipitating the encounter, the abrupt way in which defendant stopped his vehicle, and the aggressive manner in which he approached the woman, the record supports the lower court's determination that it was reasonable for the officers to believe that defendant might menace, assault, or commit another crime against the woman. Defendant argues, and the appellate division dissent concluded, that even if the officers initially had the reasonable suspicion necessary to temporarily detain him, it evaporated when he stopped approaching the woman in response to the officer's instruction because he no longer posed a threat to her. Thus, according to defendant, when he turned and ran, the officer's initial suspicion did not justify their pursuit. We reject the notion that a suspect can legally flee a level 3 stop so long as their flight dissipates the reasonable suspicion of the crime that initially gave rise to the stop. Rather, we hold that police may pursue a suspect who flees an ongoing, lawful level 3 stop. Unlike flight from a level 1 encounter based on an objective credible reason, which allows police to approach to request information, or level 2 encounter founded suspicion of criminality which gives police a common law right of inquiry, a level 3 stop permits a forcible stop and detention for questioning and a frisk for weapons if the officer reasonably suspects that they are in danger of physical injury by virtue of the detainee being armed. DeBoer, CCPL 140.50, 3. A suspect's flight in response to an attempted stop based on reasonable suspicion therefore interferes with officers' legal authority to temporarily detain them. Thus, unlike a level 1 or 2 encounter, an individual's right to be let alone and refuse to respond to police inquiry cannot justify flight from a lawful level 3 stop. Holmes, C. Martinez. There is therefore support in the record for the finding that the police had reasonable suspicion to pursue defendant, and the lower courts properly denied suppression of the drugs. C. Martinez. Accordingly, the order of the appellate division should be affirmed. Decided on April 15, 2025.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law